else. This is dismissed for lack of progress and prejudice.
This is dismissed for lack of progress and prejudice. That line came from a sitting judge, not a defense attorney filing motions, not an appellate court reviewing the record years later. A trial judge on camera in open court at a final pretrial hearing. And when she said it, the prosecutor on the other end of that Zoom call had no answer. Docket 23-130, 1FC. People of the State of Michigan versus Carlos Lee Anthony. The Attorney General's office representing the prosecution. Ronald Berry appearing for the defense. 8th, 2026. A final pretrial hearing. The last scheduled stop before trial. By this point, every piece of evidence should have been exchanged, every witness listed, every file in order. That is what a final pretrial means. It did not go that way. The hearing opened like most do. Appearances for the record, a brief competency check for the defendant. Standard procedure.
Good morning, Your Honor. Michael Dobie, P76671 for the people.
Thank you.
Good morning, Your Honor. Ronald Berry appearing on behalf of Mr. Anthony, who is standing to my left or right at the podium.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to you the truth, whole truth, and nothing but the truth on the penalty of perjury?
Yes, ma'am.
You put your hand out. Thank you for wearing a suit. I rarely see defendants wearing suits, so appreciate that. Okay. Have you taken any medication yesterday or today?
No, ma'am.
Alcohol, marijuana?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
You had enough time to talk with your attorney?
Then the defense attorney, Ronald Berry, raised something that stopped the room cold.
And there's two, are there two files? I only have one listed. Is the final pretrial on both or on one?
It's just on the one, Your Honor.
All right, thank you. This is docket 23131 FC, People of the State of Michigan versus Carlos Lee Anthony. Counsel, your appearances for the record.
Good morning, Your Honor. Michael Dobie, P76671 for the people.
Thank you.
Good morning, Your Honor. Ronald Berry appearing on behalf of Mr. Anthony, who is standing to my left or right at the podium.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to you the truth, whole truth, and nothing but the truth on the penalty of perjury?
Yes, ma'am.
You put your hand out. Thank you for wearing a suit. I rarely see defendants wearing suits, so appreciate that. Okay. Have you taken any medication yesterday or today?
No, ma'am.
Alcohol, marijuana?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
You had enough time to talk with your attorney?
Yes, ma'am.
And has there been a plea offer in this? This is a final pretrial.
There
This
has
is
not
a
been,
final-
Your Honor, in discussion with the defense
I
attorney.
can't, I'm sorry, sir. You need to stay closer to your mic. We can't understand you.
I apologize, Your Honor. No, there has not been a plea offer made in this case. In discussions with the defense attorney, it was made clear that the defendant would only accept a misdemeanor, so there was no real negotiation beyond that.
Counsel?
First of all, I don't discuss the subjects of our negotiations. We had a conversation. I don't know that I ever said that he would accept any offer, let alone whether it's misdemeanor or felony. In this matter, he maintains his innocence, and we've negotiated as such. Where we're at right now is Mr. Dobie had indicated to me 3 months ago that he was going to follow up with law enforcement about getting discovery that's outstanding, and I haven't heard anything since. We don't have the body cameras, the motor vehicle camera videos, anything of that. I understand this is the AG case was transferred to the AG's office from Withholding County.
Wait.
But this whole we don't have it.
Stop a minute. This is a 23 case. Sir, how is it this information has not been given to counsel? 2 years, 3 years.
He told the judge that 3 months earlier, the prosecutor, Michael Dobie from the Attorney General's office, had told him he was going to follow up with law enforcement to get the remaining discovery.
Where we're at right now is Mr. Dobie had indicated to me 3 months ago that he was going to follow up with law enforcement about getting discovery that's outstanding, and I haven't heard anything since. We don't have the body cameras, the motor vehicle camera videos, anything of that. I understand this is the AG case was transferred to the AG's office from Withholding County.
Wait.
But this whole we don't have it.
Stop a minute. This is a 23 case. Sir, how is it this information has not been given to counsel. 2 years, 3 years.
Body camera footage, dash camera footage. The recordings made the night of the arrest, referenced by name in the police reports. Barry said he had not heard anything since. The judge turned to the prosecutor. This is a 23 case, sir. How is it this information has not been given to counsel? 2 years, 3 years. What's going on here? Dobby's first answer was that a lot of what the defense requested simply did not exist. He said the evidence was not there.
Your Honor, a lot of the things that he has requested simply don't exist. 4 body cam videos were located by a subsequent search by the detective sergeant now on the case. And
the microphone. So you said a lot of what is requested doesn't exist. And then what did you say?
4 body cams that had not been previously provided to my office were provided. They have been provided via a download link to Mr. Barry this morning.
Via what?
A download link, a link to download.
Download link.
Then he kept talking. 4 body camera videos, he said, had been located by a detective sergeant through a subsequent search. And those 4 videos had been sent to Mr. Barry via a download link that morning. The judge stopped him. So you said a lot of what was requested doesn't exist. And then what did you say? Dobby repeated it. 4 body cam videos that had not previously been provided to his office were now provided. Sent to defense counsel via download link that morning. During the hearing, the judge asked one more time, slowly and directly. They're out.
So, is there outstanding evidence that you have not provided to defendants in 3 years?
No.
Outstanding evidence that you have not provided to the defendant in 3 years? Dobby said. No. Barry stepped back in. He explained that back in November, Dobby had sent him a download package. 172 files. Barry had confirmed receipt and confirmed with Dobby directly that the package did not include law enforcement recordings. He said Dobby had never emailed him, never communicated with him about the 4 additional videos. He only found out they existed because Dobby mentioned it out loud in court just now.
Are you?
Well, frankly, Your Honor, I'll have to talk to Mr. Dobie to find out when this stray email must have been sent for me to download some additional body camera. It's interesting. I'm being told that much of it doesn't exist, which what I'm asking for is body cameras and dash cameras. And then in the same vein, being told 4 body cameras are sent to you. I don't know. I guess I'll have to look at them. But I know there's lots of law enforcement that were involved with this. They're referenced in the police reports. And to be simply told they don't exist, I want to get some follow-up on here. I guess I'll have to file a motion to compel, and we can get evidence.com records to prove whether or not they exist and what efforts Mr. Dobie has taken, if any.
Total package, Dobby then confirmed, was now 176 items sent that morning within the last half hour.
But the additional 4 videos, so the entire reference 176 items. So sending everything again was sent this morning to Mr. Barry, like within the last half an hour.
So the 4 additional cameras were sent this morning, and I've received no additional information. Okay, now I understand.
Okay. Well, let me understand.
They didn't exist before this morning, apparently. That was the defense attorney, and no one in that courtroom corrected him. The judge had heard enough. She offered Dobby a lifeline. She told him to take out his phone, go through his email right there, and show the court when those files were actually sent.
You can go through, it's going to take 10 seconds. You could do it right now. I'm happy to wait. You can go through your email on your phone. Just don't say anything yet. You can go through your email on your phone, whatever, and look, and if you never received it.
She said plainly that if he had never received them from law enforcement, she was inclined to dismiss. Dobby started to respond, but the fuller picture was already on the record. The videos existed, they were referenced in police reports from the beginning. They had just been handed over at a final pre-trial 3 years into the case. The judge did not wait for a motion to compel. She did not schedule another hearing.
Here's what we're doing. This case is dismissed.
Here's what we're doing. This case is dismissed. Dobby interrupted. He pointed out there had been no formal motion to compel. He said there had been no showing of wrongdoing by any party.
I'm sorry, Your Honor. There's been no motion to compel. There has been. You're dismissing these because only
I'm
because
dismissing these, so you
Mr.
go
Barry
get your
says.
act together and you can reissue it. This file is 3 years old. This man is due a speedy trial, and this information is not new. I rarely do this. I can't think of one time in 22 years I have done this, but this seems to me to be unfair and prejudicial, and you can reissue. You can take your time and reissue when everything's put together, and then we're going to do all this again. And am I causing taxpayers money? Yes, but you know what? This man has been reporting to pretrial services for 3 years. The date
Your
of
Honor,
this offense
respectfully,
was,
he is
yeah,
not.
respectfully,
This
if
has
you
been on
interrupt
2
me again,
years.
you will be picked up and put in lockup for contempt.
Then she responded, she told him.
Okay. The bench warrant that I have was in 2024. We are in 2026. The first witness list that I have here from the people was in 2020, let me see, 2024, August of 2024. This is a final pretrial. My expectation on a final pretrial is that you are all ready, not that we go back to square one like when he was charged. And you certainly can file a motion for reconsideration or do whatever it is you want to me, but this is truly unconscionable here. In August of 2025, he was held in contempt and served 17 days. So between August and now January, there was plenty of time for this evidence and the files from both sides to get in order. I don't know why we're at final pretrial, and now there's claims of things that have been in possession of law enforcement and the Attorney General, and I suppose the Ingham County prosecutors for all these years and not been turned over. So as far as I'm concerned, a lack of progress is violating a fundamental right to presumption of innocence and freedom. And believe me,
The offense occurred February 15th, 2022.
Fall through the snow like everybody else, and you're on Zoom. This offense occurred February 15th, 2022, and I am not a judge who just dismisses things lightly. And you can ask everybody in this town, you can go down to the Court of Appeals, and you can do whatever it is you want. But this man has been under our charge for 3.5 years or so, and things have not been turned over until now, and now I'm hearing they need more and more time. There's constitutionally protected rights. When you all get here, and there's no statute of limitations on a life offense. So when the Attorney General gets their act together, so will everyone else. This is dismissed for lack of progress and prejudice.
She told him the benchmark hearing she had on record was from 2024. She noted the prosecution's first witness list had been filed in August of 2024 at a case that was now at final pre-trial in January of 2026. Scared, she noted that in August of 2025, the defendant had been held in contempt and served 17 days. 17 days in custody. And between that August and this hearing in January, with all of that time, the evidence still had not been pulled together. She said she had not dismissed a case this way, 22 years on the bench.
And these are life offenses. They're very, very serious. But so is the lackadaisical attitude, maybe on both sides, maybe on all sides. I don't know, but I'm not going to stand for it. The resolution is to either file a motion for reconsideration or simply recharge defendant. No, we're done with this file.
Your Honor, may I ask the court issue the order so I don't have to worry about an objection, 7-day rule and all that?
There's one right there, print it. We'll send it over to him and I'll sign it.
She addressed Carlos Anthony directly.
Just do the blank one. I'm not, so sir, I suggest, you're not skipping town, you got another file in front of me. I suggest that you are the most law-abiding person on the planet. I don't like what happened here. I don't like these charges. I don't like this whole situation. But you do have a right to a speedy trial and a right to have an exchange of information that is timely. And this is simply disturbing. And I know everybody's busy. No one knows that more than me. And I had 100% criminal docket. I get it. But this speaks to laziness on your part, your counsel's part, the prosecutor's part, the Ingham County prosecutor's part, and that's not a justice system. That's a lazy system.
She told him he had a right to a speedy trial. She told him he had a right to timely exchange of information. She told him he had been reporting to pre-trial services under the court's charge for 3.5 years. And then she turned the words squarely at every office that had touched this file. This speaks to laziness on your part, counsel's part, the prosecutor's part, the Ingham County prosecutor's part. And that's not a justice system. That's a lazy system. That's not what I'm going to tolerate. She signed the dismissal order from the bench.
All right, this matter is dismissed without prejudice for the reasons stated on the record. Any objection to that, counsel?
No, Your Honor.
On behalf of the Attorney General?
None beyond what I've already stated.
Great, send a message to your office. I expect timeliness, especially on a final pretrial. You all get your ducks in a row or this will happen. I don't know what else to say. I have not done this in 22 years. But this does not sit well with me. Well, make sure you all get a copy of this. That's all for this record.
Dismissed without prejudice, meaning the Attorney General's office could refile if they chose to. She acknowledged that. She told Dobby they had that option. She even told the defendant to keep working with his attorney because the charges could come back.
They may very well reissue, so I suggest that you deal with your attorney and maybe you continue working on this. I really don't know. I'm not giving you legal advice, but they do have the option of reissuing this immediately, and they can do that. But message sent, I hope. That is all. I'm going to sign the order. We're going to...
She made clear what the record would show regardless of what happened next. Message sent, I hope. That is all.